Hello, everyone, and welcome to our second interview of the SDG governance interview series. As mentioned already in the previous chapter of this collection, my name is Matteo Fermeglia. I am assistant professor of climate law at the University of Amsterdam and external researcher at Asset University, Belgium. And I also carry out this interview on behalf of the project co-PI, Professor Melanie Marcotte, who is Professor of Environmental Law at Cape Town University. Together, Professor Marcotte and I are coordinating the SDG governance project, which is funded under the UOR program, the Flemish Inter-University Council program, through Hasselt University in Belgium again, which basically supports partnerships between Flemish universities and universities in the Global South. The idea between the SDG governance project is to look at how UN Sustainable Development Goals, the SDGs, work, in particular with reference to specific governance actors in Europe and in Africa, in terms of how they perform in implementing the SDGs, either deliberately or not deliberately, including, relevant for today's interview, courts in the European and the African continent. So basically, our aim is to foster North-South dialogues among lawyers, academic practitioners, and the like, in regard to the SDG governance. So the governance of the SDGs as a tool in times of global crisis, foremost climate change. And we want to generate, therefore, innovative responses to such global crisis, including, of course, bearing in mind its many human rights applications. Today, the guest for our interview is Lindlyn Moma. Lindlyn is Director of Advocacy of the Laudato movement, which is a global movement, although, of course, for South Africa is based in Johannesburg. Lindlyn is also guest lecturer at Pretoria University Law School. And Lindlyn will talk to us about specifically the role of courts in the African continent and in South Africa in the implementation of the SDGs. Hello, Lindlyn. Thanks for being with us.
Thank you for having me.
Thank you again. So I will just start right away with the first question to you, which is a relatively general question, but and it is the following. So what is the role that you see for courts in Africa and in South Africa, more specifically perhaps, when it comes to the implementation of the SDGs, in particular with regard to climate change and SDG number 13?
Thank you so much, Matteo, for having me in this podcast. And I'm really excited to write this, to be part of this book. So I see the role of courts in implementing the SDGs in a variety of ways, also really depending on the legal systems, yeah? So the SDGs are regarded as soft laws, and the courts do have a role to play in interpreting and applying, the SDGs, basically in relations to policies, to make sure that the government policies align with the principles and objectives to SDGs. Also, the courts can review actions of governments and other public authorities and also corporations who are mostly charged with or have to implement various principles of the SDGs, various sections of the SDGs. When you look at, for example, energy, which is one SDG number 7 that I'll be focusing on, courts can review government actions and also the actions of corporations in applying SDG 7s. Again, the courts have a very big role in protecting the human rights of individuals and communities. In the cases that I'll be discussing in the book chapter, I'll be referring to community and civil society cases that have been brought to the courts to hear about, instances of environmental degradation, social injustices, community rights violation, or just economic inequalities when it comes to projects that intersect with realization of the SDGs. The courts also promote accountability, making sure that principles such as free, prior, informed consent, compensation principles are adhered to when, applying projects that intersect with the SDGs. So the courts really have an intersecting role here to play. They also foster public participation and advance judicial capacity in the whole. I just want to say also that, in the cases that I'll be discussing, the courts have really in South Africa brought out some landmark judgments that really highlights the intersections between applying the SDGs and, just local projects on the ground. I'll be referring to some cases from the Amadiba Crisis Community Group. I'll be looking at the most recent case of Sustaining the Wild case, NPC and others versus the Minister of Mineral Resources and Energy and others that just, have very recent court rulings that really look into the environmental and community impacts of projects that are done on the ground that may be sustainable projects, in quotes, but sometimes really violate the principles of the SDGs.
Extremely interesting. Thanks for this, Lindlyn. You touched already on some points that I want to delve into as we move forward, but I will come back to that. Then I think my follow-up question would be also in relation to what you just said, is whether you see SDGs as playing a central or peripheral role in the court's reasonings, and whether they are deliberately or not indeed deliberately, let's say, embraced, adopted, let's say, enforced, so to speak, in court.
I think in most of the cases that I've examined, the SDGs do not really come out playing a central role in these court judgments. They come out, they're not implicit, but they come out explicitly. So the courts would usually refer to them, or we can draw out from the court's judgments that they are referring to the implementation of SDGs in the bigger concept of sustainability or sustainable development, without necessarily referring to one or two or three SDGs in general. So there's still much more that has to be done there for the courts to implicitly, there's still more that has to be done for the courts to explicitly refer to the SDGs. And we now, in the book, that the chapter I'll be writing, we implicitly draw it out. And I think that is the courts have done a bit progress in looking at sustainable development concepts as a whole, but in referring to the SDGs, not necessarily. I mean, in some other cases, I need to remember those cases. There have been some reference to the Millennium Development Goals, but not necessarily to the SDGs as discussed per se.
Okay, that's very interesting, actually. Thank you very much, Lindlyn. And again, following up to this point, I would ask you if you can think of specific SDGs that you believe are particularly relevant. You mentioned already SDG number 7. And so if you could elaborate on that, or you can think of other SDGs that could be very prominent in proceedings and judgments of African courts, more generally, or South African courts, and if so, why would that be the case?
Thank you for that, Matteo. I think I would stick to SDG 7 that refers to energy, the right to access energy. And this is a dilemma in Africa right now, because the main causes of the climate crisis is fossil fuel emissions, mostly from oil, coal, and gas. And that is what is used to produce energy in the current times. Most of our energy comes from fossil fuels, and Africa is a continent that does also have the lowest amount of access to energy. And that is one thing, even the African developmental agenda is very hard on, the pursuit of energy for development. So Africa is on a course to get energy. However, there's a dilemma here on the type of energy that Africa would get. So we see many projects around energy in Africa. We see many countries striving to get energy, and usually from conventional sources like coal, oil, and gas, which is what is causing the climate change. And this is where we see a big imbalance, because even though there's a quest to get energy, if we're sourcing out energy from the wrong sources, your oil, coal, and gas, you definitely are, not contributing to the achievement of the Paris agreements. So here we see a dichotomy between, what are the sustainable ways of getting clean energy, as put in SDG 7, and how countries are implementing this, and also how it intersects with community rights violation. The case Sustaining the Wild Coast, NPC, and others really goes into the depth of this matter, that talks about, seismic exploration of the wild coast to dig in for oil and gas reserves. And the communities came in to say this was directly in contravention of the Paris Agreement, because South Africa is committed to realizing the Paris Agreement goals, but South Africa is also seeking to get more energy. I mean, we are in an energy crisis now. So, this chapter is really interesting for me because, it looks at how SDG number 7 can be realized, but also the controversies there of realizing it so that it doesn't violate the whole principles of the Sustainable Development Goals and also the principles of achieving the Paris Agreement to curb the climate crisis that we are in. So I'll be delving a bit more into SDG number 7 and how the courts have applied this. Also with how it interfaces with its communities, and not just communities, but also governments and private sector players.
Agreed. SDG number 7 obviously is on the spotlight here. Thank you for this, Lindlyn. And I would then just quickly sort of pick up on a point that you mentioned already before for my next question, which would be related to the legal nature of the SDGs, because SDGs, basically, legally speaking, you would regard it as soft law, that are not binding, but can inform both policy developments and decisions, as opposed to hard law, which normally are seen more as binding obligations, directly enforceable, and so on. So in your view, as far as courts in South Africa or in Africa more broadly are concerned, what is the role that you would assign to the SDGs? You already hinted on that. Perhaps more of a hard or soft law in terms of steering decisions?
I would agree with you that they are soft laws, that needs to be properly applied by various arms of government, but also, bringing in the likes of civil society, bringing in the likes of your corporate or private sector players. But one thing that this book is really interesting for me, and this particular chapter, is that when you're looking at SDGs, the usual players that come into the room is governments, various arms of governments, the interplay between government agencies in applying the SDGs, and also, your private sector players that bring in so-called sustainable developmental projects. But courts are usually not thought of. And courts are usually like a wave, like a far element, or an agency that is not really thought of implementing the SDGs. So in this chapter, we'll really be looking at how courts have implicitly or explicitly brought in that aspect of realizing the SDGs through soft law. And I'm really keen here on researching the various cases. I think I found a couple more cases that really refer to how the courts have brought in not just the theories of sustainable development, but in particular the SDGs itself within their judgments, within their reasoning, and hence applying that soft law. So I would say yes, SDGs would really be soft law in the context of Africa. Yeah.
Okay, this is very, very interesting. Again, insightful. Thank you for this. And the last question then also, which again, I think draws from what you just said about African courts somehow embracing the SDGs, giving it some more hard substance, probably beyond what they are meant to be, or they are deemed and recognized to be in general. The question would be, what is, in your view, the value or potential of judicial dialogue, North-South or South-North judicial dialogue, when it comes to engaging on the implementation of the SDGs?
Oh, that's a very interesting one, Matteo. And that's a really that's a novelty in this book, because it looks at the North-South dialogue. I would say really for the South, the cases that I refer to, it really raises awareness about pressing social and environmental issues in the Global South and the way they are interpreted in the Global South, the aspect of community rights, the aspect of, free prior informed consent, the aspect of how one sees energy consumption and how they can source that energy to be consumed. It's very different from the way it's viewed in the Global North. So I really look forward to also working with my colleague in the Global North, who is also looking at this issue of how the courts have been, how it's been implemented in the Global North. The second thing I would like to say is that I think when we look at how SDGs are applied in the Global South, we look at it from the cases I've seen, really look at indigenous groups also, and how they partner with civil society, to really challenge the government, something that is really not, common, but we are seeing a wave, we're seeing more and more civil society partner with indigenous groups to really challenge the government on so-called developmental projects. And then the third thing is that, at the core of this is whether how we interpret the SDGs. Are they sustainable or not? Or are they only developmental for a particular group of people? So that, the issue of what is developmental in the North and in the South is it's quite interesting here, because what may be viewed as developmental in the global North may not be viewed as developmental in the global South. So also how it is monitored, but like how the SDGs are applied and monitored, it's quite interesting to see the differences, because the right to access to energy is quite a big thing, which in the global South, but that's not a big thing in the global North, right? Because that has already been achieved. So then how that energy is accessed and the way in which it's accessed is seen differently by both civil society, indigenous groups, governments, and private sector players. All of this plays out in the courtrooms. So yeah, it would be really good to see how the North-South differences play out here.
Thank you very much. I think this is a very valuable, let's say, closing note. Indeed, that also stresses the value of the project of carrying out, let's say, a holistic view, trying to embrace different perspectives on issues that technically are universal, but they can indeed trigger different angles of view. And I do take on your comment on how much SDGs are developmental. I think this is something that courts can actually address and perhaps are addressing. So thank you for your time, Lindlyn, for being with us and all the insights on the UN SDGs, on the implementation in courtrooms. As Lindlyn has mentioned, more is to follow related to our forthcoming book, our forthcoming collection on the SDG governance project. So more North-South insights or South-North insights will come on how SDGs are being implemented. So let me thank you once again, Lindlyn, for your time and for sharing your thoughts with us. And this has been the SDGs at Work, episode number 2. Stay tuned for more to come. Thank you, Lindlyn.
Thank you.